I appear today on behalf of the Coalition for HealthCARE and Conscience. Joining me is my colleague Larry Wortham, the Executive Director of the Christian Medical and Dental Society of Canada, which is a member of our coalition. We represent more than 5,000 physicians across Canada and more than 110 healthcare facilities and almost 18,000 care beds and 60,000 staff. Today we will address the need for amendments to Bill C14 to protect conscience rights for physicians and healthcare facilities. Our members are committed to caring for their patients at every stage of life. We know what it is to journey with those who are facing great suffering in mind and body. We are committed to serving those who suffer with a compassionate love that is rooted in faith and expressed through the best medical care available. What our members cannot do is perform or participate in what is being referred to as medically assisted death. To be clear, by participation, I also mean playing a role in causing death by arranging for the procedure to be carried out by someone else through referral. We acknowledge that the draft legislation tabled April 14th set aside, at least for the moment, some of the most disturbing recommendations from the Parliamentary Joint Committee. We remain concerned, however, that the bill does not protect the conscience rights of healthcare workers and facilities with moral objections to euthanasia and assisted suicide. We see no reference to conscience rights in Bill C14. The preamble to the legislation notes that the government respects the personal convictions of healthcare providers. While that respect is appreciated, it does not carry the same legal weight as legislative protection. No foreign jurisdiction in the world that has legalized euthanasia-assisted suicide forces healthcare workers, hospitals, nursing homes, or hospices to act against their conscience or mission and values. It appears that the federal government is leaving this issue to the provinces and territories for consideration. But if the federal government enacts a law that establishes euthanasia-assisted suicide across Canada, it needs to provide robust protection of conscience rights across Canada. It is essential that the government ensure that effective conscience protection is given to healthcare providers, both institutions and individuals. It is simply not right or just to say to an individual, you do not have to do what is against your conscience, but you must make sure it happens. It is equally unjust to require a healthcare facility to repudiate its institutional conscience or mission. We would note that no healthcare facility in Canada makes every procedure available to its patients. We will continue to journey lovingly with our patients every day. We ask that you protect all healthcare workers and the institutions that are successors to the pioneers of healthcare in our country to ensure that they may continue their mission of care and healing.
We wish to make it clear that should Parliament legalize medical aid in dying, we will not in any way obstruct patients who decide to seek that procedure, and we will never abandon our patients. We know that there are many ways to respect patient decisions that do not violate the conscience of healthcare workers or institutions. The Canadian Medical Association and other experts have said there is no necessity for there to be a conflict between these two values. Our own proposal recommends the use of transfer of care and direct patient access so that patients have the choice of staying with their physician for care or transferring care to another physician. Facilities that cannot provide the procedure on their premises are prepared to help transfer patients to the facility of their choice, if the patient so desires. To force providers to act against their moral convictions is to breach Section 2 of the Charter of Rights and Freedoms. And we know that hospitals and regulators all across the country are right now developing policies on this subject. For example, the College of Physicians and Surgeons of Ontario have already provided a provisional policy that will force doctors to provide referral for euthanasia and assisted suicide. While at the same time, at least 7 other provincial colleges have not taken that approach. Legislation from Parliament would send a clear signal that the charter rights of caregivers all across Canada can be protected. Canadians should not have to deal with a patchwork approach. Parliament Parliament has legislated matters that overlap into provincial or territorial jurisdiction in the past. Consider, for example, the Civil Marriage Act, passed by Parliament in 2005 to legalize and regulate same-sex marriage. While marriage falls under provincial jurisdiction, this is federal legislation which governs marriage. The Act contains language in its preamble and a specific clause recognizing that officials of religious groups are free to refuse to perform marriages that are not in accordance with their religious beliefs. Our coalition recommends that Parliament use the same legislative approach in Bill C14, including language both in the preamble to the bill and in a specific clause that confirms that individuals or faith-based healthcare institutions who oppose euthanasia or assisted suicide are not to be compelled to engage in it and are not to be discriminated against as a result of their opposition. It is not in the public interest to essentially discriminate against a category of people based solely on their moral convictions and religious beliefs. This does not create the kind of tolerant, inclusive, or pluralistic society that Canadians deserve. Thank you.
Cardinal, you spoke about the need for conscience protections, and I'd like to ask you about conscience protections for health care institutions, faith-based institutions. There are some who are not supportive of conscience protections for faith-based institutions. They seem to distinguish between, on the one hand, health care providers as individuals and institutions, and in so doing they characterize institutions as bricks and mortar. This view seems to be inconsistent, for example, with the pronouncement of the Supreme Court in the Loyola decision, wherein Justice McLaughlin recognized that under Section 2, health practitioners and institutions are intertwined when it comes to freedom of religion and freedom of conscience. I was wondering what your comments might be on those who would say that health care institutions are merely bricks and mortar and therefore are not worthy of conscience protections.
Well, I think with healthcare institutions, what we call their conscience, we call mission. And from the earliest days of our country, the religious sisters who founded healthcare in our country, they're driven by their mission of serving other people. That is at the heart of who they are, and it is to this very day. Like, I live right next to a Catholic hospital where it presents itself as the urban angel, protecting the people, and it does do that. That spirit, that mission of that hospital is something profound. It is what I would call an institutional conscience. It is something very precious, and if institutions like our Catholic hospitals and others of other faiths are not bricks and mortar, they're the spirit of the people there who are helping. And so I think that's a very narrow and misguided view of groups of people who give their life to help others, and without whom this country would be a colder, harsher, rougher place, without the love and care of people serving a mission as a hospital. It's just not bricks and mortar at all.
And when Cardinal, do I have time, Chair? Okay. And in the absence of conscience protections, could you comment on what you're hearing in terms of what impact that may have on health institutions, many of whom have been providing quality health services for decades? I know that in the province of Alberta, Covenant Health, for example, is one such example where in the absence of conscience protections, this becomes a major problem. Would you be able to comment on the impact it will have if Parliament doesn't act with conscience protection legislation?
Well, I think it would be a very serious impact. I noticed when we got together to make a statement in the parliamentary press room a while ago, the Salvation Army also was standing. We were side by side because they also have hospitals which are very much, they're very concerned about that. So I think it's the institutions, which are these healthcare facilities, are there to serve. And if they are not allowed to do that, that would be a very serious problem. And of course, the individuals as well. Individual healthcare providers are the doctors, nurses, pharmacists. These are people who also need to be protected, and also not just about their conscience rights not to perform these procedures, but also to effect a referral to make them happen.
And last question, and it is directed to Mr. Worthen. You had read a proposed conscience protection clause, and I haven't seen the text of it. You may have submitted a brief, but I haven't had an opportunity to review it. Based on what I heard, is it modeled after Section 3.1 of the Civil Marriage Act? Is that effectively the structure of that specific proposed amendment? It sounds awfully similar.
It is very similar. It was based upon that legislation.
Thank you.
If I had the opportunity, I'd like to ask one final question, if I may, to the Coalition for HealthCARE and Conscience for either Cardinal Collins or Mr. Worthen. There was talk of institutional conscience. There was talk of mission, and that institutions ought to be provided conscience protection in the bill. I wasn't sure if you could speak to the requirement, if any, of a transfer to another facility if a particular institution is not willing to provide this constitutionally guaranteed service. I'd like your position on whether that institution or that practitioner with conscience objection should be required to make a transfer or referral of a patient.
Well, if I could just respond to that. Part of the problem in this debate is the definition of referral. When we talk about referral, we're talking about a formal referral, which essentially is a recommendation. If patients are in a facility that is not able to provide assisted death on the premises, then our moral beliefs allow physicians within that facility to facilitate a transfer of the patient to the facility of their choice where they can get access to that procedure. Similarly, if a patient comes into a doctor's office and wants assisted death, and the doctor is a conscientious objector, there are a number of ways to deal with that. One of them is transfer to another physician. Another is if the provincial government were to develop a process of direct access for this, then the patient could actually keep their physician. There are many, many ways that we can ensure that patient requests are respected while at the same time protecting conscience.